Is now in session.
All right. Thank you, Angie. Welcome to the Court of Appeals afternoon session. I want to thank you and your clients for agreeing to participate in oral argument via Zoom. It is our way of trying to keep the wheels of justice turning during this difficult time. I want to make a couple of announcements before we get started. First of all, I'd like to introduce your panel. Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Both of you are experienced practitioners in the appellate process, so you know how we do things, but just for the record, each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. Also want to thank Jim Hibner, the clerk of the court, and the deputy clerk, Angie Dempsey, for participating in this and making it happen, as well as the AOC technology staff. Miss Angie, anything before we get started?
No, Your Honor.
All right, you may call the first, or you may call this case.
James Howell et al. Versus Lee R. Morisy, MD et al.
And we will hear from the appellant.
Good afternoon, Your Honors. I'm Catherine Anderson from the Memphis Bar. I'm going to argue for 11 minutes and reserve 4 minutes for rebuttal. I represent Dr. Morisy in this case, the defendant. The judge has ruled on January 4th that we would be disqualified under Rule 1.7 of the Rules of Professional Conduct. This is not a 1.7 case. We followed the rules in this case to the letter. In 2016, when I first met with Dr. Miller, I represented Dr. Miller in another case, and I represented Dr. Morisy in this case. I met with them ex parte by consent, and we discussed the case. And just as he said in his deposition that he gave in March 2017, he said that he told me some things that he would not have done that Dr. Morisy did. He specifically said in 2016 that he would not be an expert for any side. And he continued to say that. The trial was actually set April 2nd of 2018, and it was never disclosed at that time that Dr. Miller would come and give an expert opinion. It was reset for July 16th of 2018, and it was never made as a disclosure of expert opinion that Dr. Miller would appear at that trial as an adverse expert. It was not until December of 2018 that he was disclosed as having an adverse expert opinion as the standard of care and causation, and would testify live at trial. That put us into 1.7. At that time, I went to general counsel for Baker Donaldson, who is Sam Blair, and I said, I need to know exactly what to do. It's a conflict of interest with the current client and the defendant. Reading the rule, we did everything correctly. I talked to Dr. Miller, explained the conflict. We got a waiver of conflict of interest letter signed by him and one signed by Dr. Morisy. Both clients were apprised of the whole situation and what it meant, and both signed that waiver of conflict. So after I had the waiver in place, I did a discovery deposition of Dr. Miller, and it went well. There was no tearing him apart, no going after his personality or any information I might have known from defending him in another case. It wasn't until December 27th that my partner, Brad Gilmer, received a phone call, not from Dr. Miller, but from Mr. Smith, telling us that Dr. Miller had revoked his waiver of consent and was going to be upset if I cross-examined him. On the 28th, I called Dr. Miller and said, I hear that you've revoked the consent. And he said, yes, that he had. And it was a consensual conversation, not a unilateral decision, but a consensual decision that I would no longer represent him in the Kintner case, that I would obtain new counsel for him, withdraw and substitute them as soon as possible. Now you have to know this is December 28th, and there's very few judges on the bench. There's very few attorneys in town. In fact, I wasn't even in town. So I had to wait till we could get new counsel. There wasn't time to put a motion to withdraw down. So I got new counsel as soon as possible and got an order entered by interchange because the Kintner judge wasn't on the bench on January 4th, before we argued this whole motion. Mr. Smith did not file a motion to disqualify me. He filed a motion to prevent me from being allowed to cross-examine Dr. Miller, and in fact would also disallow my experts or Dr. Morisy from opining in any way about the opinions expressed by Dr. Miller. That motion, if granted, would take away my client, Dr. Morisy's constitutional right to a fair trial. I've just never seen a motion like that. It was so absurd. So we go to argue it. My point is, on December 28th, when I withdrew from representing Dr. Miller and did no further work on his case and did not talk to him further after that, that it became a Rule 1.9 case, that this was a former client. And this was not a case where I dropped a client for another client like a hot potato. This case was, this situation was thrust upon us, and it was not due to anything that we had done. We had followed that rule. We had a letter signed by both doctors waiving any conflict until Dr. Miller met with Mr. Smith in preparation for trial December 27th. Everybody was copacetic and happy, and life was going forward. I don't know what happened in that meeting. I don't know what Mr. Smith told Dr. Miller I was going to do when he was on the stand, but Mr. Smith called and said the letter had been revoked. We followed Rule 9 to the letter. The Morisy case is not substantially related to the Kintner case in which I represented Dr. Miller. Dr. Miller understood that I had past representation of him and that absolutely nothing I had learned from representing him could be used against him in cross-examination in the Morisy case. I didn't change sides. I didn't represent one client who was suing another client. There is no risk that any confidential information, if any had been known, would be used in the Morisy case. There's great concern the court expressed about how Dr. Miller felt about this situation and his comfort level in being cross-examined by former counsel. But no one seems to care about Dr. Morisy, who is going to be denied counsel of his choice. I have worked on this case for 4 years. This was 3 days before the trial started that the judge disqualified us, leaving Dr. Morisy with no counsel and no way to defend himself, especially if Mr. Smith's motion was granted and he couldn't even cross-examine one of the adverse experts. So,
Anderson, let me ask you, when you talked to Dr. Miller in November of 2016, I assume you discovered at that time that he treated Mr. Howell after Dr. Morisy was discharged.
oh, yes, sir.
And that the actions he took was different from the actions that Dr. Morisy proposed. So even if he was not going to be an expert for the plaintiff, you know that he could have been called and his evidentiary deposition would have been taken. And at that testimony, even though he's not the expert for the plaintiff, that testimony would have been harmful and adverse to Dr. Morisy. Is that right?
Well, he actually was deposed in March of 2017, an evidentiary deposition as a treater. Now, what needs to be understood here is that Dr. Morisy last saw Mr. Howell at approximately 1:42 p.m. on January 28th, and he was fired after that. And his note shows what the condition of Mr. Howell was, in his opinion, at 1:42 p.m. Dr. Miller did not see Mr. Howell until 7 p.m., almost 5 hours later on the same day. And Dr. Miller even agreed a patient can change rapidly, especially a patient in Mr. Howell's condition. Dr. Miller stated that he felt he was in extremis at that time and needed surgery, but did not do surgery for another 16 hours, preferring to see him go to dialysis the next morning and see if he could remain stable. The two experts that have been deposed in this case, that are the experts for Dr. Morisy, said that they would not have considered him an extremis, given that Dr. Miller could wait till the next afternoon to do surgery. Does that mean that they're adverse to each other? Dr. Miller had no opinions about standard of care and no opinions about causation, just that the patient needed surgery.
Did he have no opinions, or was he advised by Mr. Mitchell not to express an opinion?
Dr. Mitchell was Mr. Mitchell was his attorney. I do not know the content of their conversations. You would have to ask Dr. Miller if he had waived attorney-client privilege to talk about it. I do know that he said, I'm not going to be an expert numerous times. 2 years between my first conversation and when he was deposed initially in 2017. He never wanted to be involved as an expert until the very last second in this case.
But you understood from your meeting with him that there was a conflict. Otherwise, you would not have needed a waiver of the conflict, would you?
Well, once he became an expert, I did need that waiver. He signed on as an adverse expert in December of 2018.
And you got the waiver
when the conflict was.
And when did you get the waiver?
In December of 2018. As soon as I found that out, I talked to him, got the waiver, we went forward.
Okay.
All right, thank you. Mr. Smith, we'll hear from you as appellee. You're muted. You're muted. Your mic's muted. Still muted.
Us old people aren't very technological.
Can't hear you.
That do it?
There you go. There you go.
It lets it. Before it was saying the host would not let us unmute. Sorry.
Well, that makes oral argument a lot shorter.
I'll try to be short anyway. I would like to start by addressing Judge Armstrong's question. When,
You need to introduce yourself first.
sorry, Gary Smith for the appellees. With respect to what Dr. Miller told Ms. Anderson in January of 16, she says that he told her then he wasn't going to give expert opinion testimony. That's not in the record, so I don't know whether that is accurate or not. But what we do know is this, because this is in the record, and Dr. Miller has testified that at the time of that January 16 meeting with Ms. Anderson, he advised her not only of his disagreement about the patient's condition as opposed to that of Dr. Morisy, but also that he held opinions that Dr. Morisy deviated from the standard of care and that it caused harm which would not otherwise have occurred. And that happened in January of 16. So from that point forward, there is a conflict. When Dr. Miller gave his deposition in March of 17, Mr. Mitchell showed up with him, announced that he would not give standard of care or causation opinions. But what Dr. Miller did do in that case was give adverse testimony to Dr. Morisy about the patient's condition. And there is nothing in this record ever, not once, not a scintilla, that says that the patient's condition changed between the time that Morisy left and Miller came on. Nobody has said that happened. Whereas Dr. Morisy had described the situation basically as the patient was doing fine, nothing else needed to be done. Miller comes in and says he's on death's doorstep, absolutely is going to die without surgery, but is so far gone that he can't take him to surgery without dialysis, which he did, and then performed what turned out to be the life-saving surgery, even though there were many, many complications and near-death experiences over a period of months. So shortly after, or within months, Ms. Anderson then identifies experts after Dr. Miller's deposition. Her two experts, Drs. Veller and Bierman, both took issue with Dr. Mark Miller's opinion expressed in his deposition, and even went so far as to say that Dr. Miller did not believe what he said based on their own conclusions. We also had identified our own expert, Dr. Rick Miller from Vanderbilt, who testified in his discovery deposition about his conversation with Dr. Mark Miller, in which Dr. Mark Miller said all the same things to him that he ultimately has come forward with in the case. As a result of that testimony, Ms. Anderson, let me back up. When Veller and Bierman testified and attacked Miller's opinions, again, the conflict is there. She is offering testimony through expert witnesses against her own client opinion and in effect his credibility. Then in March of 18, she filed a motion in limine to prevent Dr. Rick Miller from testifying about his conversation with Dr. Mark Miller. And in that motion, she acknowledges to the court specifically that Dr. Mark Miller is adverse to Dr. Morisy. Clear conflict acknowledged. Then in true December of 18, Dr. Mark Miller, now having found out that he is going to be attacked, what he has so far said, as limited as it was, but yet adverse to Dr. Morisy, decides he'll come forward and give all his opinions. The effort with the affidavit or the waiver of conflict, according to Dr. Mark Miller, he did not understand that he would still be attacked at trial, which he was going to be. And in fact, in response to the motion that we filed, and we only sought the relief, extraordinary as it was, of preventing the impeachment of Dr. Mark Miller because of conflict of interest. We were 10 days from trial. We didn't want to lose our trial setting. In response, while still representing Dr. Mark Miller, Ms. Anderson filed a response that attacked Dr. Mark Miller and said that his testimony would be biased and untrustworthy. Clear conflict. That was filed on January the 3rd, and it was on January the 4th that she got the order withdrawing from the representation of Dr. Miller.
Does that cure the conflict, Mr. Smith?
Absolutely not, because we're under 1.7. It is a concurrent conflict. Rule on that, as we believe, and we've cited all the case law on this, is that when a client is dropped, and by the way, that's the exact language that Ms. Anderson used before the court, that she dropped once she even recognized that the conflict existed. She dropped Dr. Miller. That conflict is to be judged at the time of the events, not when a motion is filed with the court. So this was a concurrent conflict under 1.7, and that withdrawal absolutely does not solve the conflict. There is no way for Dr. Morisy to defend this case without going full bore attacking Dr. Mark Miller, because everything Dr. Mark Miller says is against Dr. Morisy. And that has been apparent since at least January of 16 to Dr. Morisy's side of the case. And to drop him at the last second does not cure the conflict, nor take this outside of 1.7. So when the hearing on the 4th took place, the court determined, based on all this history, and I haven't even given you all of it, the court determined clearly that there was a conflict, that it was a concurrent conflict under 1.7. At that hearing, Ms. Anderson's position with the trial court was, if you find that there's a conflict, you are obligated to disqualify us or allow us to withdraw. The judge ultimately gave her the option to withdraw. She declined that, and the judge ruled that there was a disqualification. But the argument came up then, well, we had this agreement with Dr. Miller, waive the conflict. And so the judge ordered a hearing the next week for Dr. Mark Miller and Dr. Morisy to be there to receive testimony supposedly limited to whether or not Dr. Mark Miller was going to stand by his affidavit withdrawing his consent or waiver of conflict. Dr. Miller appeared, he testified, I did the correct examination, in which he confirmed that he did not want to be impeached or attacked by the lawyer who had been representing him. He was not comfortable with that, did not like that, et cetera, and reaffirmed that he held the adverse opinions both on standard of care, causation, and the patient's condition, and had communicated all of those to Ms. Anderson in her January of 16 meeting. Ms. Anderson had Sam Blair from her office there, who then conducted a cross-examination, and these are not my words, the courts have found it was a very adversarial cross-examination, extremely aggressive, and he was allowed to go well beyond the original intent. The judge allowed him latitude to go further than the original intent and limitation of the motion. But the judge found that even though she had already decided that there was a conflict of interest, that hearing, with the conduct of the cross-examination being as adversarial as it was, even made it more obvious that there would be a conflict or continue.
In that cross-examination of Dr. Miller, was there anything that was used in that cross-examination that would have been disclosed by him to Ms. Anderson or her firm while they were representing him?
No, absolutely not. That did not surface, nor do I believe that that's the issue. The issue is when you have a concurrent conflict of interest with the loyalty that the lawyer is duty bound to uphold to the client, can you then turn and go after them to impeach them, to impugn their credibility and their integrity, as has been done in the written pleadings relative to this motion? And I think the answer to that clearly is you cannot do that. And that was the primary focus. But no, to answer your question, he did not try to go into any information Ms. Anderson would have learned of a confidential nature based on that representation. No. In Ms. Anderson's motion to reconsider the original ruling, I know she has stated for this court in the pleadings that they did not drop Dr. Miller. Well, that was exactly what she said in that motion to reconsider, is that we, quote, dropped him because there was a conflict. So, and the other issue that you had asked to be addressed was whether or not the court considered other alternatives. And the answer is yes, the court did. There were 6 alternatives that the court considered. And that's not including the fact that she gave them the option of withdrawing rather than disqualification. We've already discussed our motion for there to be no cross-examination of Dr. Mark Miller or impugning of him, and that was denied. Ms. Anderson had filed a motion not to allow Dr. Mark Miller to testify. That was denied. The court considered whether to allow another Baker Donaldson attorney to do the cross-examination of Dr. Miller. And that was rejected because, and this is under RPC 1.01, the firm and Ms. Anderson are considered one and the same for representation. And in fact, when they did their waiver letter, it was Ms. Anderson and Baker Donaldson on Baker Donaldson letterheads. That would not work. The next thing that the court considered was whether or not to allow an outside attorney to do the cross-examination. And our position on that, and the court agreed, was that does not solve the problem because there's the entire rest of the trial. At every phase of this trial, in order to defend Dr. Morisy, you have to attack Dr. Miller all the way through. So just having someone from the outside come in and do the cross-examination does not solve the problem, because for the rest of the trial, Ms. Anderson would be having to attack Dr. Mark Miller. She considered an admonition, but clearly there was no way an admonition was going to solve the problem. So there has never been presented any other potential alternatives. All of those were considered, rejected, and I would respectfully submit it for appropriately so. That's all comments that I have. Thank you.
Thank you. All right. We'll hear from the appellant. I believe you have 4 minutes, Ms. Anderson.
Yes, sir. Mr. Smith keeps referring to our cross-examination of Dr. Miller as an attack. I certainly had no reason, nor would I in trial attack the man. This is a medical malpractice trial, and the most important part of a med mal trial are the medical records. There was a 5-hour period between the visit of Dr. Morisy and the visit of Dr. Miller. Patients can change. It's all in the records. That's the only thing we were going to go through is the records. Nothing about his social life or his hobbies or whatever else Mr. Smith thinks I might have attacked him for. We had, as soon as there was a conflict, we had a waiver in place. We followed the rules to the law, to the letter. There was no conflict until he signed on to be an adverse expert. Many doctors have many opinions about other treating doctors and other doctors who've been sued that they express all the time. But until they say, I'm going to testify as an adverse expert, there's not a question about a conflict. And as soon as he revoked his waiver through Mr. Smith, instead of telling us, we called him the next morning to verify that. a very congenial conversation. It was a consent that I would withdraw and he would have new counsel. It wasn't a unilateral decision on my part to drop him. When the judge on January 4th heard this argument, I had already withdrawn as counsel for Dr. Miller. When she heard the argument, the motion was to prevent us from cross-examination of an adverse expert, which was absurd. And if indeed she was going to grant that motion, as absurd as it was, we would have no choice but to ask to withdraw so that Dr. Morisy could have a fair trial, which he was not going to get under Mr. Smith's motion. Dr. Morisy wants us to stay on in this case. Dr. Miller is a former client. There's no substantial relationship. And you can read the record, it's all there. We followed the letter of the law and dealing with these conflicts.
Let me ask you, what is your case authority for the position that you take your snapshot of whether there's a conflict at the time of the hearing on the motion, or whether you take your snapshot at the time the conflict first surfaces?
It is in our brief, and see if I can find it here. The case that we cited actually found that the conflict didn't exist until the cross-examination. It was the Hernandez case, which is quoted in our brief.
Right, but didn't the court in Hernandez say that whether or not there was a conflict that required disqualification, that should have been assessed before the trial and before the cross-examination of that witness?
It was. It was. As soon as he became an adverse expert, we accessed, the conflict and dealt with it.
Okay, all right.
All right, thank you, counsel. We appreciate your argument. We'll do our best to get you an opinion on this matter at the earliest time possible. We again appreciate you participating in this appellate Zoom argument. Angie, I believe that concludes the call of the docket for today. So if you would please recess court. And you're muted, Angie.